So there are a couple things that have come up on this. The first one is that a motion for a in-person hearing was requested, I believe, by Mr. Groom. Is that correct?
Yes, Your Honor.
And why do you need the in-person hearing? Why are you requesting it?
This is complicated. There's lots of documents. There's a lot of there's going to be testimony from multiple witnesses. I want to be able to see how the witnesses react. I want to be able to communicate clearly with my clients during the trial. This is not going to be well, I mean, you're going to control how long this is, but I don't think this is going to be a 5-minute or a 10-minute eviction trial like the ones we've just seen.
Well,
So
those were all mostly defaults, right? So they
right.
tend to go pretty quickly. But okay, Mr. Kilday, do you have a response to that?
Yes, Your Honor. I think that in the abstract, I'm indifferent whether it's by Zoom or in person. I've had a 3-week trial by Zoom with parties in all 4 time zones, so I'm comfortable with this format, even though I agree with Mr. Groom, this is much more complicated than the other matters you've heard this morning. We're prepared to proceed and to do so by Zoom. When the motion was first made midday yesterday, I was objecting to doing today's hearing in person simply because it was not logistically possible for me to get copies of all of the exhibits in place. But if there's a resetting to a different date, hopefully in the next 5, 6, 7, 8 days, then we could do it in person. We could do it by Zoom. I'm okay either way. Today I wanted it Zoom because I just heard about the request midday yesterday.
All right. So the issue then is obviously for today's purposes, we're moving forward with the Zoom hearing today. We have another issue that we have to take up still. And so for that purpose, we're going to go forward. If you're not opposed, Mr. Kilday, to a reset so that it can be in person and the 2 parties agree, my understanding is that you both have already had an agreed resetting on this case. So, my general rule is once you've reset this case, especially on evictions, there is a time requirement that has to be met within the 21 days. And so if you've already reset this one, that means that it puts us outside of that time requirement. So you both would have to be in agreement in order to do that, to reset the case in order to make it a live hearing. And so that's the issue that needs to be dealt with here first.
So for our purposes, time is of the essence. There is a sense that our client feels that there's an effort to kind of run out the clock and not address the issues that are needed to be addressed. And so we're not in favor of a lengthy delay. If the other motion that Mr. Groom has filed on objecting to a visiting judge, if that is granted and there's a resetting, hopefully, as I said, very soon in the next 3, 4, 5, 6, 7 days, then we would be fine with that resetting being in person or being by Zoom. But our preference is to go forward today since time is of the essence.
So any type of resetting would be within the week. So it would be within 7 days. And it really depends on the court's docket and whether it's me or Judge Holmes or if it were somebody else, because we still have to address that other issue separately. JC, what dates are available for an in-person hearing?
So all of our in-person hearings are approved by Judge Holmes, just because all of our dockets are via Zoom. I don't see anything available next week, especially with the holiday. It would likely be the following week.
So, Mr. Kilday, the question then to you is, would you be open to 2 weeks? Because the only other option is that still Judge Holmes has to approve that since this is her court. I'm not going to, go over her on that, so. I mean, I've sat in this court many, many, many times. I've done jury trials in this court. I've done them in my own court when I was the presiding judge at JP5. So, and I've done hundreds of trials. So that's neither here nor there. The question is really about the parties on what you can agree to.
And we have no objection to this being heard by you, and our preference is to go forward today. I can't agree to a 2-week postponement just due to the urgencies of this matter. And so our preference is not to agree to a resetting that would be 2 weeks out. If it could be later this week or first of next week, then we might consider that. But I know that Mr. Groom has objected to you hearing this today as a visiting judge. And my concern is we're just going to be back in that loop of objections to other judges and scheduling conflicts. I know I've got a mediation in Dallas that second week of July. And so I'm just concerned that we may or may not be able to find an agreeable, workable date. And then we're just kind of kicking the can down the road.
All right. And JC, are there any settings this week available? Regardless, Judge Holmes is not available this week, right? So.
That's correct. So we don't have another judge scheduled.
All right, Mr. Groom, you want to respond?
Yeah, so my biggest issue with the Zoom hearing is that I'm going to fumble the technology and do a bad job. I mean, I'll just be blatantly obvious with you, Judge. I prefer to do stuff in court. I've been doing this for 32 years, and that's how I learned, and that's what I like. And maybe I'm a stubborn old mule. I don't know, but that is what I prefer. With the visiting judge, I didn't even know what judge it was going to be. It's not a personal attack on you. I just think I have a right to do it, and I really want to do this in person. So I made that objection when I wasn't going to get told whether or not I can do it in person.
And Mr.
And
Groom,
I was told, one more thing. I was told that by the staff because the judge couldn't rule. Not like they were being rude or anything. They were very helpful.
and Mr. Groom, I take no offense. In my own court, I've had plenty of people object to me, but it's usually more of a tactic than it is for any other reason. Because obviously, when I was a presiding judge in the court, you can't object to a visiting judge when it's the actual judge, right? And I get what you're saying, because I had to try a divorce case with 2 clients that were Vietnamese, and we needed translators during COVID via Zoom. And it was one of the very first ones, and it was absolutely the worst experience of my life. So I get it. But with all of that said, I have to take into consideration the issues specific to this case. And in this case, there has been a reset previously. The notice for the Zoom hearing, I think, is not timely under the circumstances. So I'm going to deny the in-person hearing at this time. So the next issue then really is on the objection for me sitting hearing the case. You do have that right to object to it, but my concern is the basis of the objection, like you said, that really it was just simply, that you didn't know who was sitting, and that wasn't even the issue. My concern is this just simply to delay this matter? And so we already know that because it's been delayed once, and because it's going to be a problem to reschedule this hearing, certainly within a timely manner, that I'm going to deny the motion on the visiting judge, the objection to the visiting judge. What I am going to do is, in order to give you a little bit more time, I will hold you guys off just a little bit. Let me get rid of, or not get rid of, but let me attend to these other cases, because there's only a couple more. And then that way we can give you all the time that you need. Mr. Groom, any type of technical issues, we will all be patient with you. Don't worry about that. That will definitely be handled so that it's fair for everybody. I'll give you each 2 minutes for a quick opening statement if you wish to do so, Mr. Kilday.
Yes, Your Honor. Thank you. This is a lease that exists between a church, my client, and Acton Academy, which is the defendant. This is a case for non-payment of additional rent in the form of indemnification that is owed under the lease and is characterized as additional rent, and also for non-compliance with the lease on a number of different matters. Principally, this discussion is going to revolve around a fence that was installed by Acton Academy on the church property without either the church's permission or the city of Bee Cave's permission. And it encroaches on a neighbor's property, and the city ended up assessing fines or threatening to assess fines against both the church and Acton Academy if that fence were not removed. And it took legal action in the form of demands from our firm to finally get Acton Academy to take steps to remove that fence. It's not completely gone. The foundations are still there, but I think the city's no longer breathing down our necks, but the fence has not been fully removed. And at the time that we made our initial demand, our notice of default, March 31, 2025, the attorney's fees that were owed under the indemnification of the lease were just north of $4,900. And there's never been any effort to pay that. And then we've had a cascading series of additional defaults relating to safety concerns, relating to no background checks, relating to unsafe and unclean conditions, debris scattered around that was unsafe for the children or for our church members. And I can go on and on and on, blocking the exits and entrance doors to the church, using the sanctuary and not putting it back the way that it was intended to be, and so forth. And so now that we've not had the payment of the indemnification additional rent that was owed, it's now mushroomed, as I predicted it would if it wasn't timely paid. And now we're looking at north of $30,000 sitting here today, and it's only going to go north from there if we continue going forward. So we're here to get rid of possession. We're here to enforce the additional rent that is owed, and we also have a guarantee from Mr. Briggs personally, so we want the judgment to be against both Acton Academy and its guarantor, Matthew Briggs. I've probably run beyond my 2 minutes, but thank you, Your Honor.
So before I let you speak, Mr. Groom, I'm going to ask the obvious. When you said that the amounts here are in excess of $30,000, why are we here if this court doesn't have jurisdiction on that?
Well, the court had jurisdiction when this started. It was a much smaller amount, and so that's been our frustration, is the delay tactics and kicking the can down the road has just cost more and more money going forward.
Right. Well, and with that said, this court has exclusive jurisdiction on eviction matters.
Right.
And so for that purpose, and I don't know what damages you're seeking, but obviously there's a jurisdictional limit of $30,000. Obviously 20,000, sorry. And so, we'll kind of keep that in mind. Mr. Groom, would you like to make a statement?
I would just be a little brief, but in my cousin Vinny opens up saying everything that guy says, and I don't remember his exact words, and I'm not going to be as that blunt, but we strongly disagree with Mr. Kilday and the church. What the evidence is going to show is that Acton leased this property in August of 2023. There was a great relationship with the original pastor, and in October-ish of 2024, there was a new pastor. They sent a written notice to terminate the lease effective July 31 of this year. So this lease terminates in July. They sent that notice in July, or in October, right after she got there. And then it became a pattern of nitpicking and harassment and just silly claims. The first letter they sent, they're reviewing the wrong lease. So he sends a claim for indemnification when he didn't even look at the right lease. The second letter is looking at the wrong lease. And this is all going to come out. It's all in the petition. The third letter, after things have been cured, they say that there's a late fee due, cleaning fee dues, and utilities due. All three of those things have been paid. Okay, we have the canceled checks. We'll present them. Everything's been paid. Everything's been done that they've asked. And they're just, I don't know why, but the new leadership of the church doesn't like that they entered into this lease, which is fine. They had a right to terminate it. They did. It terminates in July. To evict these people impacts numerous families whose kids go to school there. They are out on the 11th. This was told to them. This case is actually moot, if you think about it, because by the time you rule, we appeal on Monday, because we can't move out. So even if we lose, which I don't think we're going to, but we appeal on Monday, you do the bond, the court issues the papers to the county court. They can't hear it. By the time they hear it, they're going to say it's moot. The people have left the property, just like you said in 2 or 3 cases today. So this is really a case of harassment on their claims where you said they don't have jurisdiction. I would note that page 4 of the petition, they're suing in the original petition for $20,972.96. They just pled outside of the jurisdiction of the JP, right in their pleading. It's on page 4 at the very bottom, last sentence, for a total of $20,972.96. You can't fix that. You can't plead above the jurisdictional limit and then say, oh, I only want to go for 19,000. And they're going to submit evidence for 30,000, which is insane. And then I'll tell you that if you read the claim for eviction, which is required by 510.3, they have to tell us what the reasons for the eviction are. And they say, we bring this claim against Acton for eviction, forcible entry, and detainer, and also bring a claim for enforcement of the guarantee. The church claims that Acton should be evicted due to its failure to pay additional rent in the form of past due utilities in the amount of $2,630.46, and for attorney's fees in the amount of $18,342.50. When we look at the leases, the lease, which we're going to do, you're going to read paragraph 14, which is the indemnity clause. It just doesn't apply. Okay, there was no claim, there were no fines, there were no losses. There is an attorney's fees clause, which is a prevailing party attorney's fees clause. They haven't prevailed. I don't think they're going to prevail, but they haven't prevailed, so we don't owe them these outrageous attorney's fees. And then the other thing I would point out to you, we saw 3 or 4 attorneys testify today. They asked for like $900 and $800 for an eviction. These guys are asking for $30,000 to do an eviction. I mean, come on. Attorney's fees have to be reasonable. That's just not reasonable. I don't care how many attorneys are at Graves Doherty. I don't care what they bill at. They have to bill reasonable for the services they're doing. That is not a reasonable fee. So, Your Honor, we're going to go through all this. We're going to show you all the details. Acton has cured. Acton has bent over backwards to please the Reverend. And none of this is material. None of these breaches are material. The church contacted the city of Bee Cave to cause this problem, and we took the fence down. Not once did we say we weren't. The issue was the fence provided safety for the children. Children are playing on the playground without a fence. If the church is on Hamilton Pool Road, without a fence, if a ball rolls out on Hamilton Pool Road and a little kid chases it, that's a safety issue. That child could get run over by a car. That's a 45-mile-an-hour street, I believe, and people drive on it faster than that. And so I don't want to present our whole case here. I think I've given you enough, but we have cured every single alleged breach. Their letters and their timetables are completely wrong in their original allegations. Their attorney's fees claims are absurd, and the indemnification clause does not apply. And we're ready to proceed, Your Honor.
All right. JC, can you put Mr. Kilday, Mr. Groom, and myself in a breakout room?
Yes, sir, I can.
So this case is a little bit more complicated. It is going to take a little bit more time. There is no way I believe that we're going to get this finished today. Certainly not prior to the other hearings that we have scheduled. And so I want to make sure that everybody has a proper opportunity to present their arguments. So we're going to need to reschedule this. We've agreed on Friday. At least everyone so far has come to the agreement that Friday is the best day, Friday at 9 a.m. JC, what we're going to do is we're going to come in person. For those that can, there may be 1 or 2 witnesses that might have to appear via Zoom, but at least counsel and myself will be there in person. I know that we still need to get this approved by Judge Holmes. So if you'll reach out to her, but it's in order to move this case going forward, it's the only, I think, viable option under the circumstances.